Mr. Richard Novak, Rohak Viche, and appointing them along with Ms. Catherine Nestor to be Mr. Robinson's counsel. The court enters findings that the combined experience of counsel meets and exceeds the requirements of Rule 8. Counsel, do we have, what would we like to accomplish today?
I have two items, Judge. I just wanted to make a record that under Rule 16 of the Utah Rules of Criminal Procedure with respect to discovery, the state is required to provide to the defense within 5 days of the defense's request the discovery that we relied on in making this charging decision. We'll be prepared to do that, so we'll look for defense counsel's request over the next day or so, and we'll provide that to the defense.
Thank you.
We also, for the court's information, we met this morning with the defense team briefly in our office to talk about discovery and the process. So we'll be working together. There is a substantial amount of discovery in this case, Your Honor. It's voluminous, to say the least, and we're working on a process where we can exchange information as quickly as possible and be efficient in that process. The other item I had, Your Honor, I saw that over the weekend, there was a protection order, pretrial and trial publicity order entered by Your Honor. And I just was seeking some clarification on page 2, at the end of the first paragraph. It reads, "To that end, lawyers participating in the investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams that the prohibitions contained in this order." The state, we're seeking some clarification with respect to the phrase "all witnesses," Your Honor. There are a number of witnesses that have yet to be identified that will likely be used in the state's case. This occurred in front of 2,000 to 3,000 students at Utah Valley University. So we're in the process of identifying those witnesses. And so those individuals are presently unknown right now. So we're looking for a little clarification from the court. And I suppose we're not going to make any arguments today, but there may be some follow-up pleadings that we may need to file.
Thank you. Ms. Nestor, did you want to be heard about that issue?
No, Your Honor, we would defer to whatever the court wants to advise them on that matter. I mean, I think it's fairly obvious that we don't know who all the witnesses are in this case yet. I think it's just important that if anyone is identified, that they have information about this order. So I think other than that, we wouldn't weigh in on any other matter.
Thank you. Well, thank you for that question. That's an important one. The court will rule that as the witnesses become known to each side, that information is conveyed to abide by this order. Obviously, there are potentially many witnesses, and so it's not the expectation that you would be able to do that up front, but as they become known, I would ask that you would inform them of this. Anything else, counsel?
Nothing from the state, nothing else, Judge.
Thank you. Ms. Nestor.
Thank you, Your Honor. We recognize that we are here today for a waiver hearing. It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However, based largely on what the state just referred to as far as the voluminous nature of the discovery materials, we do think it would be prudent to simply reset for another conference, another waiver hearing, a little bit down the road, where we have a better idea once we start seeing the discovery as it rolls in. I do recognize we're going to be getting that first batch in 5 days, but it's my understanding from our meeting today that there is massive amounts of digital that is going to be coming, and until we can kind of get our heads around exactly what we're dealing with and how much we need to process, it's going to be difficult for us to give you a reasonable expectation of when we will be ready to do the prelims. So we're asking today that we put that decision off, and maybe we could check in 30 to 60 days and just kind of let the court know where we're at and how much we're looking at and how much time we may need to set a preliminary hearing. Also, as far as a detention hearing, we are not asking the court to address that issue at this time. Under the statute, the issue is going to come down to the question of whether there's substantial evidence, which right now we're just not in a position at all to be able to even argue to the court. So we are probably going to ask that the court delay that decision possibly until the time of the prelim. But if it's sooner, we will ask the court for a hearing. But at this time, we are not asking the court to make any decisions on that matter.
Thank you, counsel. In regards to the next hearing date, how about October 30th at 10 a.m.?
That works for the state, Your Honor. Thank you.
All right.
That's fine for the defense, Your Honor.
All right. Now, as we are at the beginning, anything further from counsel from either side?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
As we are at the beginning of this case, it is my intent to only speak when I'm needed or it is necessary. But today I do wish to provide guidance and expectations that you can have for this court and wish to enter an order as well. He sits before this. As this case moves forward, Mr. Robinson's constitutional rights will be protected at every offense charged. He sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. At the same time, and as applicable, victims are entitled under our Constitution to be treated with fairness, respect, and dignity, free from harassment or abuse. Justice demands that both of these principles, the rights of the accused and the rights of victims, be honored without compromise. I remain steadfast in my oath that I made 56 days ago to support and defend the constitutions of the United States and of Utah. I will carry out my duties with fidelity, transparency, and impartiality, treating every person who appears before me with the dignity and respect they are inherently due because they are human beings. Let me be clear. I will not put my finger on the scale of justice. These proceedings will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys and participate in these legal proceedings. Also, regardless of who is watching, whether it is the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. I encourage each of you to give your very best to this case. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice. In regards to the next hearing, counsel, on that October 30th date at 10 a.m., it's the court's intent that be in person if it be the wish of counsel for the defense for Mr. Robinson to be present.
It is, Your Honor. Thank you.
Thank you. Counsel, anything else that we can address today?
Your Honor, we appreciate the court's comments with respect to Your Honor's role in this case. In like matter, we commit to approach this case with integrity, with professionalism and civility. We are truth seekers. We will aggressively pursue the truth in this case. Thank you.
Thank you. All right, counsel, unless there's anything else, thank you for being here. This court is in recess.
Stand by that. Okay. Okay. See you later. Folks.
Didn't show up, so we just checked.
Thank you guys. Thanks, Mr. Trina. Yes, sorry, Trina. And we have a team that I'm so I have to do those trees. Almost a bunch. Thank you.
Thank you so much. Yeah. Empowerment Day.